Sorry. Thank you, and thank you, Chairman and committee members. Starting my presentation with Magdalen institutions. I have to say at the start, the Taoiseach's apology and the findings of the McAleese report still stand. There is no question of walking back from either. On the question of criminal abuse, I would start by saying that the Department approved payments for 677 women, and as part of that process there's a lot of interaction between the individual women and the Department, and only in 2 cases was a reference arose to the question of a possible criminal abuse. In 1 case it was mentioned by the solicitor of the woman, but when we raised the question of referring it to the Gardaí, the solicitor objected and we didn't pursue the matter further. In another case, with the woman's permission, we arranged for the Irish police to travel and talk to the woman in question. However, she was not willing to make a formal statement and have a criminal investigation. It was quite rightly stated that the question of criminal abuse was not a specific term of reference for the McAleese Committee. The chairperson did decide to look into the matter. He interviewed a selection of women who had been in Magdalen institutions, and with 1 or 2 exceptions, the majority said they had neither seen nor experienced physical abuse. He also interviewed lay people who had access to Magdalen Andrews, and in particular doctors, to determine if they had seen any signs that would indicate of abuse within the institution, or whether the doctors had treated any suspicious injuries, and he got no indication from them. He also looked at the question of unlawful imprisonment. There was never any legal basis for detaining a woman in a Magdalen Dronry if she was an adult. And at the time, the age of majority in Ireland was 21. So that's any woman who was 21 or older. There's no legal basis for their detention in a Magdalen institution. A number of women, when interviewed by the chairman of the committee, did say that they were unsure of whether they were always free to leave. And there were a smaller number of women who felt that they were being detained against their will. But those particular cohort of women all came through the industrial schools, and there was a provision in the Act that governs industrial schools that provided that a child committed to an industrial school could be subject to controls up to the age of 21, so that there would be a legal basis for them being restricted their liberty. We have no reason to believe at this stage that there is a body of evidence out there which was not looked at by the McAleese Committee. But if there is evidence of criminal abuse that's newly available, we would be happy to receive it from any source. The McAleese Committee did look for all relevant diocesan records and did inspect material from the Galway diocese. In addition, the Department of Justice itself, and separate to the committee, did receive material from the Galway diocese because it listed a number of individuals, and that facilitated the granting of payments to those individuals because it proved that they were in that institution. There are questions of sensitive personal data regarding the archives of the McAleese Committee. A person who was in a Magdalen institution is entitled to access the religious records relating to her. So any individual who wants to access records relating to them may have access to them. There is no statute of limitations in Ireland for criminal offences. We are not aware of any civil action that has been taken in the Irish courts relating to a Magdalen institution and has failed because of the statute of limitations being invoked. Moving on to the actual scheme itself, Judge Quirk recommended that only 2 criteria be applied for the question of eligibility for payment under the scheme, and that was 1, the person was admitted to one of the specified institutions, and the second was that they worked in those specific institutions. In that context, the government decided that persons should not benefit from two schemes, with one exception. And this was an exception that was specifically recommended by Judge Quirk in his report, and that is in relation to girls who were transferred from industrial schools to Magdalen laundries under the relevant legislation, and the exception applies for the period up to the age of 18. So up to the age of the period up to the age of 18, they're eligible for possibly compensation or payments from either the Residential Institutions Redress Scheme or the Magdalen Scheme. But for the period over 18, it's limited just to the Magdalen Scheme. The question of medical assistance abroad was mentioned. The provision and statutory provision has been provided for the provision of medical assistance in Ireland. But obviously, that can't be applied to other countries because we don't have jurisdiction over their medical system. So the arrangement is done on an ad hoc basis, on an individual basis, depending on which country they're in. Arrangements are made on that basis. Now that the majority of women have been identified as have been in and have been paid, there is work necessary to progress other matters, and that includes the question of a memorial.